Thank you, Senators, for the opportunity to comment on the nomination of Judge Ketanji Brown Jackson, whom I've known personally and professionally since 1998 and whose career I have followed closely since that time. I've taught constitutional law and legal history for 20 years at the University of Virginia, and I've served as the Dean of the School of Law since 2016. Today I'm speaking in my personal capacity, not my official capacity as Dean, and my testimony is not based on the views or positions of the University of Virginia. It is based rather on my personal views as a scholar, placing Judge Jackson in both a broad historical perspective and the context of contemporary thought on the judicial role. My conclusion is that the Supreme Court and the nation will benefit enormously from the keen intelligence, impeccable integrity, broad experience, and intellectual open-mindedness of a Justice Jackson. Before I turn to the main portion of my testimony, let me add my historian's brief reflection on the historic nature of this appointment. It was some 56 years ago that the Senate confirmed Constance Baker Motley, Judge Jackson's role model, to be the first Black woman judge on any federal court. That Judge Jackson shares Judge Motley's birthday is, as has been said, a happy coincidence. That she shares her status as a trailblazer is far more than that. It is causal. She and we would not be here today without Judge Motley and others like her who paved the way. I have three main points. First, Judge Jackson is eminently qualified to serve on the Supreme Court of the United States. To illustrate with just a few numbers, she holds 2 degrees with Latin honors from Harvard University. She has served as a law clerk to 3 federal judges, nominated by presidents of 2 parties. She has been confirmed by bipartisan votes of the Senate 3 times to federal office. Altogether, she has accumulated 26 years of legal experience, 7 in private practice, and 19 in public service, including 2 years as a federal public defender, 6 with the Bipartisan Sentencing Commission, and 9 years as a judge on 2 federal courts. You know all this, but this abbreviated description both makes clear that Judge Jackson will bring enormous distinction to the Supreme Court and highlights how her varied experience will enrich both her own opinions as a justice and the collective deliberations of the court. That Judge Jackson has represented clients from well-resourced corporations to the indigent and unpopular is testament not only to her robust embrace of every lawyer's obligation to serve the public, but also to her commitment to the rule of law in an adversarial system in which every party is entitled, and criminal defendants are constitutionally entitled, to zealous advocacy. Her insights from the district court will especially enhance the Supreme Court's understanding of how trial courts implement their decisions. This brings me to my second point, about the salutary judicial approach Judge Jackson has developed out of this varied experience. As a trial judge, she has shown deep respect for precedent. She has written about the importance of stare decisis, which informs her view of the judge's role in our constitutional scheme as simultaneously crucial and modest. Accordingly, her opinions are based on precedent and committed to the rule of law. They are fact-based and pragmatic, open-minded, and analytical. Among the more than 500 cases that Judge Jackson has decided, whether the matters at hand concerned environmental regulation or immigration law, criminal charges, employment discrimination, or business disputes, she has found in favor of both plaintiffs and defendants, for individuals, nonprofits, businesses, and the government. One simply cannot presume what Judge Jackson's ruling will be based on the party's political affiliations, positions in the world, or other characteristics. Rather, what remains constant across these hundreds of opinions is Judge Jackson's commitment to applying precedents to the facts before her, maintaining procedural consistency, reasoning with common sense and humanity, and doing justice for the parties consistent with the rule of law. These traits place Judge Jackson in the heartland and the mainstream of the American judicial tradition. My final point is personal as well as scholarly, about the connection between Judge Jackson and Justice Stephen Breyer, for whom she and I both clerked. Judge Jackson is very much her own judge, and her judicial approach stems from her own experience and the mainstream currents of judicial thought in the 21st century. That said, 2 similarities bear highlighting. First, Justice Breyer and Justice Jackson share their deeply held patriotism, which they both absorbed from family members who dedicated their professional lives to public service. Judge Jackson believes as deeply as Justice Breyer in service to American values and in the value of the American Constitution. Moreover, Judge Jackson, like Justice Breyer, has always been as interested in hearing the views of others as in sharing her own. She has worked with lawyers from across the political spectrum and found consensus with her colleagues on the Sentencing Commission and the D.C. Circuit. After Justice Breyer announced his retirement, I reflected, as I think many of his clerks did, that the lessons he taught me are ones I rely on every day. the appetite for dialogue, optimism, open-minded and open-heartedness, and joy. I hoped then that they would remain with the court and the nation long after his retirement. If you confirm Judge Jackson, as I urge you to do, those virtues, both personal and judicial, will indeed remain with the court, much to the benefit of us all. Thank you.
Thanks, Dean Geloff.